Case number 20CR36423, the State of Ohio versus Brian Berger. Mr. Berger is here with counsel, Mr. Madden, Ms. Nicholson, on behalf of the State of Ohio. Mr. Berger, I ordered you to appear today to show cause why I should not terminate the privileges to drive that I granted to you. The court has received a number of reports of you drinking again and attempting to start your vehicle. Do you have some explanation for me?
Yes, sir. The times that I violated, it was the next morning. I was drinking the night before, and it was the next morning that I would get violated. And if I waited 2 or 3 more hours after that, then I was good to start my truck.
So tell me what happened. I thought you had given up drinking.
I did, sir.
You have an alcohol problem. You have 7, 8 OVI convictions. You should not be drinking. You have a history of drinking and then getting behind the wheel of a car. You're going to kill somebody. I thought you were done with the alcohol.
I was, sir. I just relapsed.
So this has been going on for several months now, the reports that I'm getting.
Yes, sir.
So what's your plan?
Well, I'm thinking about going back to like Talbot House or something like that.
Well, I don't think there should be any thinking about it. Obviously, I don't have the authority to order you to do anything.
Yes, sir.
But I granted you these privileges because you did well on community control. You remained sober while the time you were on supervision and even after that.
Yes, sir.
But now you've just like fallen off the wagon and you are a danger when you're drinking and getting behind the wheel of a car. I don't know how to emphasize that to you.
Yes, sir.
What should I do?
Give me one more chance, please.
Tell me about this second vehicle that you've purchased. We found a second vehicle registered in your name.
I purchased it back in it was 2018 or 19.
Is that car operable?
No, I purchased that before I got my that last OBI where you sent me.
But that you're saying that car is not operable.
No, it's got rusted brake lines. It doesn't run.
Does the state have a position, Ms. Nicholson?
Your Honor, he was granted privileges just about a year ago in order to get that interlock. The fact that he is reporting that the failures are left over from drinking the night before, my previous conversation with Officer Sukavecki, these were .02 and .04 kind of hits on the interlock. So, I mean, I think that speaks to the level at which he's drinking currently. I understand the court doesn't have the ability to order him to do anything. It doesn't sound like he has re-engaged despite his history with alcohol. He has numerous prior OVI convictions, and so the state does not feel at this time that it is safe for the public to allow Mr. Berger behind the wheel of a car. I understand that the interlock does give the court some security that it will not start if he is drinking, but allowing him privileges at all based on his history, he was afforded this opportunity, and it doesn't seem like he's taking advantage of it in a very positive way.
Mr. Madden, you wish to be heard?
Yes, Your Honor. Well, it does seem to make sense in terms of the level he's been blowing in the machine. That it probably was the night before, and how much he drank the night before, of course, determined what it was in the morning, but he's not blowing 08s or 08s or higher. So it does make some sense. Obviously, he's having trouble stopping drinking, and I don't know what it's going to take, but maybe today, since he thought he was here for a whole other reason, Judge, and he thought that maybe you're going to remove the interlock, and here we are. He's being berated by you justifiably for what he has been doing. So
the order that was sent to him clearly stated that he was being ordered to show cause why the license privileges should not be terminated. That was what the order was.
I don't know. That's what he called me about.
Right.
That's why he came in here today.
No, I understand. Mr. Berger, I am going to give you another opportunity. I'm going to continue with the driving privileges. I don't like this. But I don't have any authority to punish you any further. You certainly haven't broken the law, but you're certainly violating my orders, but the interlock device is working. If you want that device removed at some point in time in the future, if you want me to terminate your license suspension in the future, you're going to have to show and demonstrate to me that that you can show a prolonged absence of the use of alcohol.
Yes, sir.
And not attempting to drive after you've been drinking. So,
Yes, sir.
and again, if you're drinking that much that it's still testing 04 the next morning, that's a problem in that you're drinking that much. So you've got to make a decision. You have requested in the past that I remove the interlock device. That's not going to happen for the foreseeable future because you're not following the rules.
Yes,
You
sir.
have an alcohol problem, sir, and we tried to get you help for that when you were on community control, and I hope for your sake that you get the help that you need. Re-engage in treatment if you have to, but you can't drink. For whatever reasons there are, you can't do it. So
Yes, sir.
I'm going to continue with the interlock device at this point in time. I will not terminate your privileges, but if this continues to happen, I may revisit my decision at that time.
Thank you,
Ms.
sir.
Nicholson, is there anything else?
No, Your Honor.
Anything else from probation, Officer Nelson?
Nothing further.
Mr. Madden?
No, thank you.
All right, thank you all.
Thank you.
I can print out that affidavit.
I don't need the affidavit today.
Okay,
Sentencing.
okay, well, I'll get it out of the way today, not to give to you, but just have it in the file.
Case number 26 CR 43410, the State of Ohio versus Jessica Lease. Ms. Lease is before the court with her counsel, Mr. Bogan. Ms. Tranter on behalf of the State of Ohio. Ms. Tranter.
Your Honor, my understanding is that Ms. Lease is prepared to enter a plea to count 2 of the indictment, amended from a felony 2 to a felony 3, aggravated possession of drugs. State will ask for dismissal of the trafficking charge, count 1, and I believe defense intends to ask for PSI and set the case
There was a
out.
third count too.
Oh, the count 3, okay, I'll dismiss that as well, I'm
Okay.
sorry, that was my oversight. So if you could add that to the plea form, Judge will be dismissing count 3 as well. Request for PSI and set the case over for sentencing.
Mr. Bogan, is that accurate?
Yes, Judge.
All right, Ms. Lease, you're telling me you're going to change your plea to 1 amended count from the indictment. Before I get you to change your plea, I'm required to go over some things with you, okay? How old are you?
31,
How far did you go in school?
11th grade.
Can you read and write? Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you? Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation that you've received from Mr. Bogan?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you feel comfortable that you understand what it says?
Yes, sir.
This document says running a plea of guilty to 1 count of aggravated possession of drugs as a felony of the 3rd degree that carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. The prison term is not mandatory but presumed to be necessary. $5,000 of the $10,000 fine is also considered to be mandatory. Do you understand the maximum and mandatory penalties involved?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means if you are sent to prison, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever's longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you'll have rules you must follow as well. If you fail to follow those rules, then the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of their witnesses. Do you understand that? Yes?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charges from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes.
This is how you want to proceed.
Yes, sir.
All right, Ms. Tranter.
Your Honor, as to count 2 of the indictment as amended, it occurred on August the 7th of 2025. Warren County, State of Ohio. On that date, defendant Jessica Lease did knowingly obtain, possess, or use a scheduled or controlled substance, being methamphetamine, Schedule 2, at an amount of 27.83 grams.
Mr. Bogan, anything on those facts?
Nothing on the facts, Judge.
Ms. Lease, did you hear the statement that she read?
Yes, sir.
Do you admit that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts and your plea, the court will make a finding of guilty. I will order a pre-sentence investigation. Ms. Lease will come back in a few weeks and do sentencing at that time. Anything else, Ms. Tranter? Mr. Bogan?
Nothing else.
All right,
Nothing
thank
further.
you all.
Thank you.
That's it. Go back.
Did you go, send her back down to court services to schedule her PSI?
Yeah, just did.